Mac Mines Australia Pty Limited proposed to develop the China Stone Coal Project. The project proposed to construct and operate an open-cut and underground thermal coal mine. The project was declared a controlled action. A controlled action must be referred to the Minister for the Environment for approval under the Environment Protection and Biodiversity Conservation Act 1999. The EPBCA is designed to protect national environmental assets known as matters of national environmental significance. It was determined that the China Stone Coal Project could potentially impact on matters of national environmental significance protected under the EPBCA. The China Stone Coal Project proposed by the proponent required assessment and approval under the EPBCA because the legislation adopts an environmental assessment and approval process that is designed to ensure activities that have or are likely to have significant impacts on the environment are properly assessed. The EPBCA provides for the protection of the environment. This protection extends to those aspects of the environment that are matters of national environmental significance. The EPBCA renders unlawful any action that is likely to have a significant impact on the environment. The proponent referred the China Stone Coal Project to the Federal Department of the Environment. The Federal Department of the Environment is the administering authority for the EPBCA. The project was referred to the Federal Department of the Environment because the proposal triggered matters of national environmental significance under the EPBCA. The EPBCA stipulates that any action that requires approval is classified as a controlled action. A proposal that meets the definition of a controlled action must be referred to the Minister for the Environment for approval. The Minister is obliged to determine whether or not the action is a controlled action, and the Minister must ultimately consider all adverse impacts relating to the proposal. The Federal Department of the Environment determined the China Stone Coal Project to be a controlled action. As a result, the project required approval under the EPBCA. If a project is classified as a controlled action under the EPBCA, it may be assessed at both a state and federal level. The Federal Department of the Environment determined that the China Stone Coal Project would be assessed using an accredited assessment under the Queensland State Development and Public Works Organisation Act 1971. The EPBCA allows for bilateral agreements. This includes an assessment bilateral agreement. An assessment bilateral agreement allows a state or territory to conduct a single environmental impact assessment process. However, at the completion of the assessment, the state provides a report to the Australian government assessing the likely impacts of the project on matters of national environmental significance. Under an assessment bilateral agreement, the state-based environmental impact assessment is accredited, but the Australian government makes the final decision regarding project approval. As a result, the China Stone Coal Project was subject to both the EPBCA as well as Queensland environmental legislation, being the Queensland State Development and Public Works Organisation Act 1971. The purpose of this process is to avoid or minimise the duplication of environmental impact assessment reports and statements, whilst also ensuring high environmental standards are met for the protection of the environment. Thank you.